Welcome to Transnational Competition Law course, and dear learner and viewer, today I am going to deliver my lecture on comparative law perspective on embarrassment of extraterritorial application of competition law in developed and developing countries. Dear learner, you can rightly recall my previous lectures on the issue of on the topic of the embarrassment of extraterritorial application of competition law. And in the other lecture, we have pulled out the very facets and dimensions that how the embarrassment of the extraterritorial application of competition law has been a gradual process and has been witnessing an organic growth among the developed and the developing countries. We refer especially the kind of the mechanism which we have been built upon as of now, the countries which have been very proactive in incorporating the extraterritorial application of competition law in their statute. And then, if some countries are having a trailblazer in that regard, and they have not been coming to the grip and the terms of the extraterritorial application of the competition law, then how United Nations Conference on Trade and Environment, an organization of economic cooperation and development, an international competition agency, has been acting as a bulwark mechanism and try to see that how the gaps are to be filled and to see that how extraterritoriality and extraterritorial application of competition law should be fostered at national, regional, and global level. Then, dear learner and viewer, you can also recall my lectures regarding on the various approaches to the embarrassment of extraterritorial application of competition law, and we have understood the approaches of the embarrassment in reference to Germany, in reference to Korea, in reference to United Kingdom, in reference to South Africa, in reference to France, in reference to India, and many other jurisdictions to bring home the conclusion that the embarrassment of the extraterritorial application of competition law, though it happens to be very interesting discourse, the embarrassment to the extraterritorial application of competition law happens to be a very interesting discourse. But if we go down and deep and try to see that what are the approaches which have permeated in the in the developed and the developing countries in incorporating that extraterritoriality that represents a very diversified approach, and the diversity of the approaches must be cherished in the sense that they are hitting hard to the question of conduct or anti-competitive conduct or behavior, and they are also looking at the abuse of dominance. They are also looking on the regulation of combination. They are looking on the predatory prices and price fixing mechanism, and they are also looking at the issue of the cartelization review and the merger review. Then what we see that the entire approach cannot be a uniform, and but if we have a different kind of an approach to the extraterritorial application of competition law, but prime focus and the foundational values of the embarrassment of extraterritorial application of competition law across all the jurisdictions of the world, be that the developed countries or the developing countries, happens to be one and the same, and they are hitting hard to the same direction with the very foundational values of the competition law and jurisprudence. With this, we also refer to many countries like Egypt, like Vietnam, like Russian Federation, like India, like China, like Argentina, and we have tried to see that what is the nature and extent and nature and content of the rights which have been permeated into or percolated down in the embarrassment of the extraterritorial application of competition law in these countries, in developed and developing countries. And we are not having some very sweeping generalization, but we have endeavored to peruse their provisions, and we have interpreted those provisions, and we saw the import of that provision. And in that sense, we can say that we try to see that the how the different laws of the different countries are approaching to the issue of the extraterritorial application of competition law. Though they are worded differently, but again, the unitary of the thoughts and the binary of the thoughts taken together on the issue, what we find that it appears to be a very diversified approach, and those approaches undoubtedly contribute and embellish the entire competition law and jurisprudence in comparative perspective. So, dear learner, today we are going to discuss as to what exactly we mean in the nature and content and the approach and ambit and scope of the comparative law perspective on embarrassment of extraterritorial application of competition law. So, in that reference, we will try to see that what has been handed down to us as of now in terms of the country's initiative on extraterritorial application vis-a-vis the initiative of United Nations Conference on Environment and Development and Organization of Economic Cooperation and Development and international competition agencies. We will try to see that how they have contributed to the corpus of extraterritorial application of competition law. And in that reference, we will directly trying to see that what are the nature and what are the trends of the comparative law, and how the comparative law of the comparative competition law have been a very guiding force to our understanding. In that sense, dear learner, what we find that when we look at the entire nature or nature of the competition and nature of the extraterritorial jurisdiction of the competition law, what we find it is more difficult than in a domestic context. And as we refer to the Indian example of competition law, which requires an actual and potential and appreciable adverse effect, then we can see that it is not as simple as it happens to be the United States Sherman Act or the Clayton Act, which incorporated as a matter of administrative expediencies of the effect doctrine, but the same effect doctrine which it has been transplanted in the Indian Competition Act 2002 and 2003. What we find that there are many adjectives which has been used: actual, potential, appreciably, adverse. So we find that a lot of prefixes has been done to the doctrine to see the effect or the conduct of the companies on the domestic market. Overall, we can see that the nature and trend of the comparative law on the competition happens to be that it try to frame out the extraterritoriality provision, especially in European Union, in Japan, in United States, in a different word. But what is important that we have to come out of the pounds and shells of the American Antitrust Act and European Union and the Japanese model, and we have to see that some of the smaller countries like the Philippines, how they have reacted in 2015, and the Nigerian competition legislation in 2019, and the Vietnamese competition law, which was brought into the statute book in 2004, and what remains the limits and the scope of Article 1 of the 2019 competition law in Vietnam, because the Vietnamese competition law have undergone to a kind of a metamorphosis, and that metamorphosis have to study that from 2004 to 2019, that what the Vietnam as a country have learned on the issue of the extraterritoriality and how they encounter that problem, how those problems are finally given a practical shape in their new law on the competition in 2019. So we have to take So we have to take the provisions of all the countries across the globe, and meaning thereby that we will move with the same spirit, that whatever happens to be the laws, either it is international law or it is comparative law, we have to see that the universal approach to the competition law, and we have to also underline the cross current which is found in a particular context of the competition law, be that European Union, be that United States, be that Philippines, be that Nigeria, be that the Vietnam, and we can understand then probably in a better way that what is the nature and trend of comparative law on the comparative competition law, and how that one template of the competition law can fit to all countries, or we can have some very alternative and fruitful model of extraterritorial application of competition law in matters of embarrassment of extraterritorial application or enforcement of the extraterritorial application of the competition law, and as well as the remedies of the extraterritorial application of the competition law. In that reference, dear learner and viewer, we will directly go into the details of the United Nations Conference on Trade and Development Model Law on Competition 2010 to see that how from all the sides the laws which are gushing together and find a kind of a wave, and that wave ultimately leads to a kind of a conglomerate, and that conglomerates which tries to represent the comparative competition law, uh, and then comparative competition law vis-a-vis or juxtapose to the United Nations Conference on Trade and Development Model Law on Competition 2010, that what are the parallel, what are the common features, what are the distinctive features, that has to be understood in relation to the comparative law as well as the international law on competition, be that the soft core international law or be that the hardcore international law. In that reference is in that reference, dear learner, the study of United Nations Conference on Trade and Development's Model Law on Competition 2010 becomes one of the very important exercise. As we see that United Nations Conference on Trade and Development has been continuously and meticulously engaging itself to see that how we can that they can frame out a kind of a model law which can be replicated across all the jurisdictions of the world, and then in that reference the competition law template which United Nations Conference on Trade and Development adopted in 2004 and its iteration in 2010, we have to see that how 6 years of their engagement on the issue of blueprinting a model law on the competition went, and how it has been that the some of the experiences of the comparative competition law finds its own place in refurbishing the United Nations Conference on Trade and Development's Model Law 2010. So we in that reference we see that we have to directly once again we have to refer to the 2004 uh, model law and as well as the 2010, and a very comparative analysis, the comparison and the contrast of both the laws are important, and in that reference we will take the 2010 model law, model competition law, and we will be referring to the substantive part 1 of the model law. And what we find that the model law happens to be silent on the possible extraterritorial application of competition legislation. So that is something the kind of a myopia which this model law tries to project itself to be model, but to what extent it has been modular is a question very pertinent to be raised, and that becomes a kind of a moot point for us, that whether the model law sets some model or the model law itself shrouds in some kind of a confusion, and that confusion seems to have compounded. Then it's better to see that how comparative law happens to be a good answer to the question of the embarrassment, enforcement, and as well as the remedies of the competition law in extraterritorial application of the competition law across developed and developing countries. Our Our disappointment with the perusal of Substantive Part 1 of the United Nations Conference on Trade and Development Model Law 2010 in relation to extraterritorial application happens to be a very pessimistic, but the sense of optimism can be found in the perusal or in the provisions of the part 2 and the commentaries that talks about that discuss very vividly about the cross-border mergers and amalgamations and the merger reviews and other kind of the anti-competitive behavior. So what has not been contained in the substantive part of the model law of 10 is being filled up, and have been that if we take the part 2 of the commentaries of the model law, then we find there are certain provisions. So it will be very misnomer, and it is wrong to say in toto or in a holistic manner that the model law, United Nations Conference on Trade and Development's model law 2010 happens to be very silent on the issue of extraterritorial application of the competition law. Then, what we note from the careful perusal of the commentaries of Part 2 of the model law, and then we see that it enunciates that such transactions might have direct the careful perusal of Part 2 of the commentaries of the Model Competition Law 2010 by United Nations Conference on Trade and Development have very clearly spelled out, besides its recognition to the cross-border merger and amalgamations and other kind of the anti-competitive behavior, it clearly spells out that transactions which have a direct or indirect effect in forum, irrespective of where the underlying activities have actually occurred, is a clear indication of the fact that the model law has not been very casual in its approach to the extraterritorial application of the competition law. And the commentaries contains paragraph on international and export cartel. So the specific devotion of the model law on the issue of international and export cartel and cross-border merger and other anti-competitive conduct taken as a whole, we can say that the model law serves some kind of the model to guide the countries in making and refurbishing and reforming their competition law. And that's why we see that United Nations Conference Secretariat has prepared a note dealing with the transnational anti-competitive conduct in the context of the review of UN set on the competition. And we find that as a whole that United Nations Conference on Trade and Development's model law, be that 2004 or 2010, both happens to focus on the question of extraterritorial application of competition law. Then, dear learner, we will be reflecting on the sets of multilaterally agreed equitable principles of 1980, because as we have noted that the 2004 model law and the 2010 model law happens to be model but in the actual sense of the term, that it has not some very core but peripheral mentions about the extraterritorial application of the competition law, but it is more salubrious and to note, and it is more pleasant to note that United Nations Conference on Trade and Development sets of multilaterally agreed equitable principles 1980 that deserves our attention. Why? Because it, as the nomenclature of this principle spells out, it devotes to the question of multilaterality, meaning thereby that not in a very sledgehammer manner this law is going to be applied across all the jurisdiction, bearing all the contextual context of the countries which might have a very different kind of the economy and the political economic structure. So the very word of multilaterality is something very important. It means it does not talk in terms of I, but it talks in terms of we, it talks in terms of a common understanding of all the countries. And secondly, And secondly, it talks about that agreed, it means that there is an element of consensus. There is not only the element of consent, but there is an element of consensus, and then only it can be agreed. So, something which is based on consent and prior informed consent. The consent should also be the prior informed consent, and once we have a prior informed consent and we have a consensus, then the issue of the multilaterality have a wider sense of an appeal. And the third word which appears in that model law is also very soothing to our audibility, that is the equitable principles, that is of far reaching ramification, that what we see that in matters of trade, business and commerce, there is no equality of bargaining, and the equality of the bargaining notoriously exists to one side. And here what we find that once we believe in equality and as well as the principles of equity, which is a higher law and a higher concept and higher notions of law, then what we find that equitable principles that makes a great sense in guiding the entire corpus of the comparative competition law, and then it really makes a sense of its wider acceptability. And that acceptability is important because ultimately laws have to be applied among the countries, and the countries in right earnest or in pacta sant servanda spirit that the treaties are to be respected, adhered, and to be complied with. And when we comes to the issue of the compliance and implementation of any kind of the law, be that United Nations Conference on Trade and Development set of multilaterally agreed equitable principles of 1980, there should be more compliance than any kind of a violation. In that reference, this law is very important in our understanding of what is called the comparative law perspective on embarrassment of extraterritorial application of competition law. The basic features of this multilaterally agreed equitable principles of 1980 runs that it adopts a kind of a rule which allows and which sets the control of restrictive business practices. So, it primarily, when we talk of multilaterality, it talks about the consent, it talks about the consensus, it talks about the equity principles. Then that principles is to be applied in carving out and thrashing out the entire strategy for the control of restrictive business practices. Thus, is present that in the transnational cases, the reliance on this principle of 1980 serves a great jurisdictional purposes, be that under the overall influence of the effect doctrine. That is why we will see, dear learner, that once it was promulgated in 1980, by the by the 1990s or the mid of 90s, what we find, it was considered generally and universally accepted principles of the competition law, and then it serves a great fillip, as we were not having any kind of a model law by the United Nations Conference on Trade and Development, because that law came in 2004 and only in 2010. But before that, this law has a great potentiality in serving as a model law. So we can say that the United Nations Conference set of multilaterally agreed equitable principles 1980 has been really a model law, and it was a model law before the model law of United Nations Conference on Trade and Development's model law of 2004 and 2010, because the reach of this multilaterally agreed equitable principles of 1980 happens to be a universal acceptance of the anti competitive behavior as a global issue, and then there has been a great sense of willingness to avail the benefits of extraterritoriality for the sake of protection of the domestic interest from inbound anti competitive harm. So, particularly, we see that whether it is a variety of a low or a high income states, there has been a wide range of embarrassment of extraterritoriality which has followed after 1980 under the guidance of multilaterally agreed equitable principles. In a way, we can say that the United Nations Conference on Trade and Development sets of multilaterally agreed equitable principles 1980 has created a kind of an atmosphere, an environment, an ecosystem where there has been a gradual embarrassment of the extraterritorial application of competition law, and whatever development we see, as we have seen in the study of John M. Connor, and we have seen the study of the United Nations on extraterritoriality experiences in developing countries, taken together all the literature which we have at our command on the issue of the extraterritoriality in reference to the embarrassment, in reference to the enforcement, or in reference to the competition remedies, what we find that this law have a ripple effect, and this law has went very well among the countries and has created a kind of an ecosystem where the gradual process in the 1990s and 2000 and 2010, it has been one of the contributory factor in looking at and in fostering that more and more states and countries should have their competition law. Not only they have their competition law, but they must have an express verbis provisions for extraterritorial application of competition law. With this, dear learner, I just stop here, and in the context of comparative laws perspective, I think that our discussion on the issue happens to be of some help to you in drawing a comparative law perspective, and that perspective include the nature, the trend, and the impact of the laws which we had in heralding a kind of a movement or ushering a kind of a kind of a drive where we can see that the more and more countries and states should switch over to the extraterritorial application of competition law in matters of enforcement, in matters of embarrassment, and in matters of competition remedies. With this, thank you very much, and I wish, dear learner and viewer, a very happy learning.